Hello everybody. Welcome to the MOOCs course on Information and Communication Technology. This is Archana Sharma from the North Cap University, Gurgaon. I'm sure you must be going through various modules of Information and Communication Technology, and by now you must have had some fundamental idea, concepts about this particular emerging area of law. Keeping in tune with this trend, today I'm going to deal with a module which is based on understanding of cyberstalking, cyberbullying, and cyber defamation. The learning objectives of this module are understanding of various forms of harassment on cyberspace such as cyberstalking, cyberbullying, and cyber defamation. Second, to make you aware of the existing legal provisions relating to such offenses and their adequacy to deal with challenges of advanced technology. Third, also to look into the role of the judiciary in recognizing and addressing some menace on cyberspace. And fourth, various legal and technical challenges enhancing the vulnerability of users on cyberspace. There is no doubt about the fact that the computers have become an integral part of our day-to-day affairs. While talking about increase in the usage of computer in our daily life, it has also enhanced the possibility of misuse of these machines, leading to computer-related crimes. When you talk about the computer-related crimes, we may perhaps broadly divide it into two different types. One is criminal activity using computer to commit an offense, and on the other hand, criminal activity that has computer as a target. Now, before going into the specification, the integral ingredients of these offenses, I would like to draw your attention to the data provided by the National Crime Records Bureau, which says that a total of 11,592 cases were reported in 2015 under the cyber crimes, as compared to 9,622 cases registered in the previous year, that is 2014, which shows a rise of 20.5% over the previous year. While talking about the serious increase in the rate of cyber crimes, the users unfortunately fail to recognize the vulnerabilities they are exposed to while browsing internet, uploading posts on social networking sites, or storing information in the computer. At the same time, perpetrators use the cyberspace as a platform for indulging in various criminal activities against the users. While talking about these criminal activities, one such area which has drawn almost everyone's attention, that is known as the phenomenon of online abuse, which has directly or indirectly affected cyberspace users of diverse age groups, leading to different forms of harassment. In order to understand the term cyber harassment, we may refer to various definitions that are found in the legal dictionaries as well as different laws, according to which cyber harassment may be defined as a repeated, unsolicited, hostile behavior by a person through cyberspace with the intent to terrify, intimidate, humiliate, threaten, harass, or stalk someone else. And we also have to keep in mind that any harassment which is caused through electronic media such as social networking sites, chat rooms, emails, etc. is also considered to have similar impact as any other traditional offenses relating to harassment. As far as cyber harassment is concerned, it includes offenses like cyberstalking, cyberbullying, cyber defamation, etc. As far as stalking is concerned, this has emerged as a social legal problem of the recent time, which has resulted in incorporation of this as a substantive offense under the criminal law of the country, that is the Indian Penal Code. The term stalking generally refers to following a person with intent to harass or cause inconvenience to him or her. As far as ingredients of stalking is concerned, it includes a repeated and unwanted harassing behavior. Second, a behavior which may be reflected by a physical act or even through electronic means. The act may cause mental trauma and fear to the individual, and it may also considered to be a direct intrusion into the privacy of an individual. While coming to cyberstalking as an offense, it is a serious form of harassment that takes place on the cyberspace, posing serious threat to life of an individual if it is not addressed appropriately on time. A recent threat for the cyber community, irrespective of age or any other social strata the users belong to. In fact, it is very surprising to note that in spite of repetition of such kind of activities on the cyberspace, multiple cases go unreported either due to lack of awareness or absence of stringent laws to deal with them. Now coming to the legal provisions which are existing in order to combat situation of cyberstalking. The offense of cyberstalking was not incorporated in the IT Act when it came to force in the year 2000, unless the act involved publication or transmission of obscene material within the meaning of Section 67 of the IT Act. Section 509 of the Indian Penal Code partially deals with the offense, according to which uttering of any word, making of any sound, or intrusion upon the privacy of such woman shall be punishable with imprisonment up to 3 years and fine. Since Section 509 of IPC defines this act as one of privacy, Section 72 of the IT Act was also brought into effect while dealing with cases of cyberstalking. In the course of time, when the IT Act 2000 was further amended, a new provision was inserted into the Act, which was Section 66A. The title of it says, Punishment for Sending Offensive Messages Through Communication Service, etc. Apart from Section 66A, email communications amounting to extortion may be dealt with under Section 43, Section 66, 66C of the IT Act 2000. However, in a recent development, Section 66A of the IT Act was struck down by the Supreme Court of India in case Shreya Singhal versus Union of India, which was decided in March 2015. And this particular case declared the Section 66A to be violative of the fundamental right of freedom of speech and expression under Article 19, Clause 1, Subclause A of the Constitution of India. Even though Section 66A of the IT Act has been struck down from the statute book, stalking still remains as an independent offense under the Indian Penal Code. The offense of cyberstalking is now a part of Section 354D of the IPC, if not a complete protection to the offense. And this provision was inserted by the Criminal Law Amendment Act 2013. Now, if we analyze the Section 354D, I would like to highlight on that particular aspect which probably takes care of cyberstalking to a great extent. It says, any man who monitors the use by a woman of the internet, email, or any other form of electronic communication commits the offense of stalking. The definition itself indicates towards the fact that the particular provision under Section 354D of the Indian Penal Code is absolutely silent about cases of stalking which are initiated by a woman against a man. In a way, we can call it that this particular provision is not gender neutral to deal with cases of stalking where a woman is said to have stalked a man. As far as the cases on cyberstalking is concerned, the first case of cyberstalking was registered in the year 2003 by Delhi police, where the complainant alleged that a person was using her identity to chat on internet at a particular website in obscene language. The man was also alleged to have given her telephone numbers to people in the chat room, which ended up the victim receiving phone calls from different places. This adversely affected the personal life with serious inconvenience, trauma, and harassment. Finally, when the investigation was taken up by the police, the IP addresses used by the perpetrators helped police reaching out to the individual who was responsible behind this act of stalking. The person pleaded his guilt and was arrested under Section 509 of the Indian Penal Code for outraging the modesty of his victim. It is interesting to see that even though the conviction rate of cyberstalking had been low since the coming into effect of the amendments to IT Act in 2008, the Mumbai Cyber Cell secured the first ever conviction in Maharashtra under the IT Act in July 2015. The case was investigated by the cell for online stalking in 2009. A Metropolitan Magistrate Court convicted Yogesh Prabhu for stalking and sending obscene images to his colleague. As a result, the court sentenced him to 3 years of imprisonment and a fine of rupees 10,000 and rupees 5,000 under Section 66E of the IT Act, as well as Section 509 of the Indian Penal Code. Even though Section 509 of the Indian Penal Code is taken recourse to for dealing with cases of cyberstalking, it is worth mentioning that the provision does not explicitly refer to cyberstalking, and under such circumstances, providing cases of cyberstalking still remains a challenge under the existing laws. At the same time, the purpose of Section 354D also, as I have mentioned earlier, is to prosecute a man for stalking a woman under circumstances which is described in the provision itself. In such cases, the only option left with the prosecution is to take recourse in Section 506, which is criminal intimidation of the Indian Penal Code, especially in cases which involve threat to life, injury, etc. Therefore, in the absence of Section 66A of the IT Act, there is an urgent need to amend the existing provisions so that cyberstalking can be recognized as an independent substantive offense, which is one of the most underreported offenses in the present scenario.